Our guest today is Ira Anagnosti, a partner of White & Case in Washington, D.C. Ira spent more than 10 years working for the SEC's Division of Corporation Finance. We're going to talk some Corp Fin-related matters. I'm Brock Romanek, today on Zippy Point. So Ira, so many changes in the confidential treatment request area. Went back when I was on the staff. It was one of my least favorite forms, documents to process. It was a no-win situation, not that exciting to read, and not a whole lot of excitement, period, as you well know. So the first question I have for you, and there have been a lot of changes to the process, to the rules in the last couple of years, two different spates of them that you're going to get into. But what is eligible to be treated as confidential information and not disclosed in an SEC filing these days?
So, oh my goodness, talking about changes, this area was just recently amended, not in the distant, past, where we had new item 601 to Regulation SK that introduced this concept that if information should be redacted from exhibits that need to be filed with commission, documents, then registrant didn't have to really, go through the whole confidential request treatment process. So as it stands, information can be redacted to the extent that registrants believe that information is non-material and would not cause competitive harm. So I can go through sort of, like all the requirements of how to meet that criteria, what you need to include in the exhibit index, what you need to include in the actual, exhibit itself, the way to identify the redacted information. But somehow the SEC snuck into, actually just as recently as November, in the new amendments under the facilitating capital formation, the exemption framework, these new amendments to 601, which now implements the new Supreme Court standard, the ruling that came in June of 2019 that said, listen, we're just going to go and throw away the previous standard of what constitutes confidential information that had this standard of, competitive harm for purposes of, being able to rely on exemption for the Freedom of Information Act of, what is commercial and financial information that would be considered confidential for the issuers. So now we have a new standard. The rules have been amended and they're going to take effective March 15th. And the companies no longer have to meet competitive harm, standard. All they need to do is to prove that information is customarily and actually treated as private and does not, and then obviously would not be material for purposes of an investment decision. So that's going to be the new standard under item 601. Judging from the disclosure topic number 7, which was implemented, also in 2020 and replaced staff legal bulletin number 1 that talked about, how registrars should be submitting this confidential treatment request. I believe that the staff will continue to ask for, an analysis of, to the extent the information has been redacted, does it meet the customarily and actually treated as private, as well as, providing a materiality threshold. So we're sort of in the transition period. I'm actually myself working on a filing where we need to submit this redacted information. And we're like, okay, so is the staff going to review them under the old standard or the new standard that is basically like, not even 2 months away? So I guess I will find out soon enough.
So the exhibit index, I don't know why I've always had a soft spot in my heart for the exhibit index, but what will that look like for like a 34 Act report going forward after March 15th?
So I believe that the exhibit index, the marking will remain the same, that certain information has been redacted. The same requirement will go for the facing page of the exhibit to alert everybody that some information has been redacted, including the way that you mark the information. However, sort of the basis upon which that information can be eliminated from those filing will be different. So it's under a different standard. And I do believe that even under circumstances like generally the staff will require, or it has in the past required, to review unredacted exhibits provided supplementarily under Rule 83 when you are, in the process of an initial public offering and the review of an S1 or a review or of a, 34 Act registration statement. And I think that, probably what's going to be, something that the staff will look more closely would be the materiality analysis. I think that registrars will have an easier time to prove that the information is customarily and actually treated as private, because it's something that is, something that they control, and they can, it's hard for the SEC, I believe, to sort of substitute their judgment for that of the company.
And then what about the screening process that the Corp Fin staff is now going to use when they review a filing that has redacted information? What kind of compliance review might they do to make some sort of determination?
So I think that, as I mentioned, it will probably continue to be the same for first-time filers in the context of a 33 Act filing, or in the context of first-time registration under the 34 Act. I think with 10K reviews or annual report for foreign private issuers, will it be on a case-by-case basis? As you know, a lot of reviews happen without issuers knowing that they're being reviewed. A lot of reviews end up with no comments. So as part of, the typical SOX review of annual reports, most likely the staff also take a look at, what information being redacted under the exhibits, and sort of, business as usual to some extent. But I do think that the bar is raised much higher for purposes of triggering a comment.
And if the staff does happen to ask to see an unredacted exhibit to do the compliance review, how is that actually physically sent down to the staff?
So that is an area that has developed, really in a positive direction. So no longer hard copies need to be provided to the staff. As part of the whole COVID, the world of technology, they implemented a new system, an online system called Kite. So registrars can provide the unredacted supplemental information, still subject to Rule 83, which they're allowed to request online. The staff reviews them, and at the end of the review period, that information, that they have the technology that the information basically get destroyed and no longer becomes part of the commission's documents. So that way, in a way, it's no longer within the building, if you will, and sort of the way that it was supplemented, it didn't become part of a commission filing.
And when the staff does decide to issue comments, how is that done now? Is it oral or written? And what's sort of the timing of this?
So it's kind of interesting when you read topic 7 that talks about, how you submit a confidential treatment request. If the staff reviews basically the unredacted copy and has comments, they will provide them orally, but they expect a response in writing. I would think that the staff sort of follows the same procedures, even when they review it on a supplemental basis for purposes of, the 601 type compliance. So I believe that those comments continue to be issued orally, and, requesting the registrants to provide a written response.
And then how would a company know that it has responded to the comments to the satisfaction of the staff? How does it know that the review is now closed?
So that is also communicated verbally. Hopefully the response in terms of, meeting that materiality threshold for purposes of not having to include redacted information in an exhibit is met. Otherwise, if the staff is unsatisfied, they may request that the exhibit get refiled and include in it the information that the staff does not believe that it meets the criteria of materiality and that is actually customarily and actually treated as private by the issuers.
And then extensions of previously granted requests. One of the most ridiculous things to process when I was on the staff. How does that work now?
Yes, so I think that kind of works similarly. They have, a short form versus a long form, depending on, when are you asking for the extension of the confidential treatment request. I believe that has, the number of confidential treatment requests has decreased substantially because of this sort of, like now a much easier approach to filing exhibits with redacted information. But, topic number 7 didn't really change the sort of the process by which registrants can ask for an extension. And depending on, the length of the request for confidential treatment request, you may have to resubmit the whole thing or maybe use a short form. As I said, I don't get asked very often to go through that, very tedious process. Everybody's happy to rely on the new amended Rule 601.
So you were one of the best. You were one of the best on camera. You really are, Ira. And thank you so much for sharing your wisdom with us.
Thank you. Thank you for having me.
Thanks.